Hello, you're watching Hornbill TV's Explanatory. A 5-judge constitution bench of the Supreme Court on Thursday unanimously struck down the centre's electoral bond scheme, which facilitates anonymous political donations for being unconstitutional. It underscored that the scheme violates the right to information under Article 19(1)(a) of the Constitution. And now in today's explanatory, we'll delve more into what the electoral bond scheme is and why the Supreme Court struck down the scheme. The Narendra Modi government had brought the scheme in 2018 with the stated objective of enhancing transparency in poll funding. According to the government's notification in 2018, the electoral bond is a bearer instrument in the form of a promissory note. An Indian citizen or an entity incorporated in the country is eligible to buy it. The bonds can be purchased for any value in the multiples of ₹1,000 from specified branches of the State Bank of India. The bonds are available for 10 days each in January, April, July and October. This period is specified by the centre. Payments to buy the bonds have to be made from a bank account that fulfills all Know Your Customers requirements. These bonds don't carry the payee's name and have to be used for donations within 15 days of issue. Only parties registered under Representation of the People's Act 1951, 43 of 1951, and which got at least 1% of the votes polled in the last general election or state election can receive donations through the bonds. The party has to encash the bonds through a designated bank account. The electoral bond scheme, according to the then Finance Minister, late Arun Jaitley, ensured that all transactions of poll funding happen through banking instruments. The scheme, he said, was a substantial improvement over a cash donation system that was fully non-transparent. Soon after it was implemented, multiple parties challenged the electoral bond scheme in the court. These included CPM, Congress leader Jaya Thakur and Non-Profit Association for Democratic Reforms. They argued that the confidentiality clause in the scheme came in the way of the citizens' right to information. Senior advocate Prashant Bhushan, appearing for ADR, said the bonds promote corruption as they are opaque and anonymous. The counsel for the petitioners also pointed out that earlier Section 182 of the Companies Act allowed corporates to donate up to 7.5% of net profit in a financial year to a political party. Companies needed to be at least 3 years old to donate and had to disclose the amount and name of the party to which it was donating. These conditions that ensured transparency in corporate donations were done away with under the new law, they argued. Defending the scheme, Solicitor General of India Tushar Mehta said it was a deliberate attempt to ensure that funding received by political parties was clean money. He said disclosing the donor's identity could disincentivize the whole process. When the court asked how this confidentiality can be reconciled with the voters' right to information, Mr. Mehta had replied that voters do not vote on the basis of who is funding which party, but on ideology, principles, leadership and efficiency of a party. Countering the right to information argument, Attorney General of India R. Venkatramani had said there can be no general right to know anything and everything without being subjected to reasonable restrictions. Secondly, the right to know as necessary for expression can be for specific ends or purposes and not otherwise, he had said. While Chief Justice of India D.Y. Chandrachud authored the lead verdict, Justice Sanjeev Khanna penned a concurring opinion to arrive at the same conclusions. The court also struck down the amendments made to the Income Tax Act and the Representation of People Act, which enabled such anonymous political contributions. As reported by The Hindu, the Bharatiya Janata Party had received 1,294.14 crore through electoral bonds in 2022-2023, which was nearly 54% of its total income during the year and 7 times higher than that of its main rival, the Congress Party. The court held that the scheme, by permitting anonymous political donations, infringed upon the fundamental right to information under Article 19(1)(a) of the Constitution. It pointed out that such a right is not only restricted to fulfilling the freedom of speech and expression, but plays a key role in furthering participatory democracy by holding the government accountable. Thus, it is not just a means to an end, but an end in itself. It highlighted that economic inequality leads to differing levels of political engagement because of the deep association between money and politics. As a result, there is a legitimate possibility that financial contribution to a political party would lead to quid pro quo arrangements. The Chief Justice also rejected the argument of the centre that due to the expressed anonymity of the bonds, political parties do not know the identity of the donors. He pointed out that such de jure anonymity of the contributors does not translate to de facto anonymity, since there are sufficient gaps in the scheme to enable political parties to know the particulars of the contributions made to them. On the government's argument that the scheme curbs black money and its circulation, the court said that it does not justify the encroachment into fundamental rights, relying on the proportionality test laid down in its 2017 verdict in the K.S. Puttaswamy case, which upheld the right to privacy. It underscored that the government did not adopt the least restrictive method to achieve its objective. As examples of such least restrictive methods, the Chief Justice cited the 20,000 cap on anonymous donations and the concept of electoral trusts, which facilitate the collection of political contribution from donors. The court also agreed with the contentions of the petitioners that since the purpose of curbing black money cannot be traced to any of the reasonable restrictions elucidated under Article 19(2), it cannot be said to be a legitimate purpose for restricting the fundamental right to information. During the proceedings, the government argued that information about financial contributions to political parties is not disclosed to protect the contributors' informational privacy to political affiliation. Thus, the court had to consider whether the fundamental right to information privacy, as recognized in the Puttaswamy verdict, includes information about a citizen's political affiliation. If that were the case, is a financial contribution to a political party an aspect of political information? The Puttaswamy verdict categorically recognized that the freedom of political expression cannot be freely exercised without the privacy of political affiliation. For instance, information about a person's political beliefs can be used by the state at a political level to suppress dissent and at a personal level to discriminate by denying employment. Thus, such a lack of privacy could disproportionately affect those whose political views do not match the views of the mainstream. Chief Justice held that the right of privacy of political affiliation does not extend to those contributions which may be made to influence policies. It only extends to contributions made as a genuine form of political support. The court found that the amendment made to Section 182 of the Companies Act 2013 permitting unlimited political contributions by companies to be manifestly arbitrary. The provision allows Indian companies to make financial contributions to political parties under specific conditions. However, through the Finance Act 2017, crucial changes were introduced, including the removal of the prior cap on the amount that companies can donate to political parties, 7.5% of the average profits of the preceding 3 fiscal years. Additionally, the requirement for companies to disclose the names of the political parties to which contributions were made in their profit and loss accounts was also eliminated. The Chief Justice highlighted that Section 182 errs by treating political contributions by individuals at par with those made by companies, as the latter is often made with the intent of securing benefits in return. It was also opined that such an amendment authorities unrestrained influence of companies in the electoral process, thereby violating the principles of free and fair elections. Initially, Section 29C of the Representation of the People Act 1951 required parties to declare all contributions higher than 20,000 and specify whether they were received from individual persons or companies. However, the Finance Act 2017 amended this provision to create an exception wherein such a requirement would not apply to donations received through electoral bonds. Striking down the amendment, the court observed that the original requirement to disclose contributions of more than Rs 20,000 effectively balanced the voters' right to information with the right to privacy of donors, especially since the donations below this threshold were far less likely to influence political decisions. The Supreme Court then directed the SBI and has been ordered to immediately stop the issuance of any further electoral bonds and furnish details of such bonds purchased by political parties since April 12, 2019. To the ECI by March 6. Such details must include the date of purchase of each bond, the name of the purchaser of the bond, and the denomination of the bond purchased. The ECI shall subsequently publish all such information shared by SBI on its official website by 13 March 2024. Electoral bonds that are within the validity period of 15 days but have not yet been encashed by the political party will have to be returned, following which the issuing banks will refund the amount to the purchaser's account. The recent move is now waited to see from the BJP as what their fortunes could do in the coming general elections. And that was all for today's explanatory. For more explainers like this, keep watching Hornbill TV. Goodbye.